What is up, everybody? So the Court of Appeals decision is in the Steven Avery case. I'm just reading it right now, and I will link it in the description below so you can go have a read for yourself. It's a 49-page document, and nobody wants to sit here and listen to me read 49 pages, but I will go over a bit of it, the decision and the conclusion, and you can go check out the rest of it for yourself. It states, in 2007, following a jury trial, Steven Avery was convicted of first-degree intentional homicide, party to the crime, and possession of a firearm by a felon. We affirmed his convictions on appeal. The issues in this new case concern collateral proceedings, whether the circuit court erred in denying in Avery's 974.06 motion and 2 supplement motions without a hearing, as well as his motions to vacate and for reconsideration of the first of these motions. We hold that Avery's 974.06 motions are insufficient on their face to entitle him to a hearing, and that the circuit court did not negatively exercise its discretion in denying the motions to vacate and for reconsideration. Accordingly, we affirm. So that's not good news. That means they're denying him a new hearing based on the new evidence that Kathleen Zellner brought forward. Disgusting, but not, unfortunately, not unexpected. Extremely sad. Let's go check out the conclusion. The rest of the document basically goes over the case of what he was convicted of. On November 9th, 2020, we notified the parties that this case had been submitted to the court for decision on briefs. On April 12th, 2021, Avery filed another motion with this court to stay his appeal and remand for evaluation of a new claim. This claim concerns an alleged Brady violation, the factual basis for which Avery obtained on April 11th, 2021. Specifically, the claim is based on an affidavit of Thomas Sowinski, a Manitowoc motor route driver who assessed that days after Halbach's death, while on his paper route in the early morning hours, he spotted a shirtless Dassey and an unidentified older man pushing Halbach's vehicle down Avery's road toward the junkyard. Sowinski further attests that after he delivered the paper, Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch. Sowinski claimed to have called the Manitowoc Sheriff's Office later that day to report what he had seen, but was told they already know who did it. That's not surprising at all. He also claims to have attempted to contact Avery's trial attorney after seizing one of making a murderer, but never heard back from them. Avery rises a variety of alternative theories about who killed Teresa Halbach and how, but as the state correctly notes, the 974.06 motion is not a vehicle to retry a case to a jury. A criminal defendant is constitutionally entitled as of right to a jury trial, and if convicted, a direct appeal. If he or she later seeks to collaterally attack the conviction on constitutional or jurisdictional grounds, a 974.06 motion is appropriate, but key to any 974.06 motion are sufficient non-conclusionary showings, both as to why the issue was not raised in earlier post-conviction proceeding. These requirements are not optional and cannot be met through broad conclusions or by misstating evidence. We express no opinion about who committed this crime. The jury has decided this question, and our review is confined to whether the claims before us entitled Avery to an evidentiary hearing. We conclude that the circuit court did not negatively exercise its discretion in denying hearings on motions 1, 4, and 5, in not vacating its order on motion 1, and it's not reconsidering its ruling on motion 1. As for motion 6, And the portion of motion 3, the motion to reconsider, raising new claims, we leave open the possibility that Avery may raise these claims in a new 9704.06 motion. We remind Avery, however, that he will need to overcome the, I cannot pronounce that, ESCALONA-NARANJO procedural bar on these claims, which includes providing a sufficient reason for not raising them in his June 2017 motion. Moreover, Avery will need to satisfy the previously discussed requirements before such claims can proceed to a hearing. By the court, orders affirmed, this option will not be published. So, again, you can go read the entire thing for yourself and figure out what that word was. It's on page... it's on page 48. That's a big word. Too big for me. So, unfortunately, that's not the outcome everyone was hoping for. Hopefully, Kathleen Zellner has some more, I'm sure she does, has some more ideas about what they can do moving forward. What a hard time for Steven Avery, losing his mother just a short time ago and now getting this negative result from the Court of Appeals. Again, disgusting. It's crazy that they can do this, but it's not, unfortunately, it's not a shock. It's not a surprise. Realistically, this is probably what everyone was expecting, just not what everyone was hoping for. Again, it is linked in the description below. Go check it out for yourself. Thanks for watching, and if any other news breaks, I'll be sure to bring it to you. Hope you all have a great day. See you again soon.